Okay. Hello, I am Rick Steele, and I serve as the chair of the Licensed Psychology Advisory Committee of the Kansas Behavioral Sciences Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic medium. Richard Nobles.
Present.
Jonna Norton. Abby Callis. Jessica Hamilton. Tiffany Johnson.
Here.
Janine Kesterson. Rodney McNeil.
Here.
Zachary Parrott.
Here, if you can hear me.
I can. Doug Wright.
Here.
Great. I note the following staff members are also present. David Fye.
Here.
And Leslie Allen.
I think she'll be joining us here in a little bit.
Joining shortly. Next, David Fye will read a message concerning this meeting being held remotely.
This is David Fye, Executive Director for the Kansas Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the advisory committee to provide public comment or answer questions from individuals. Individuals requesting to provide public comment could contact the executive director prior to the meeting by sending an email to david.fye@ks.gov. There will be no public comment at this meeting today, as no individuals requested to provide public comment. Because we are conducting this public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Public access to this meeting is being conducted by medium of interactive communication that allows members of the public to attend the meeting free of charge. You can do that while participating on the conference call or on the board's YouTube channel. While the meeting is conducted remotely, the requirements of KOMA are not suspended. Therefore, we'll be conducting this meeting pursuant to the KOMA. On October 28th, 2022, we sent notice of the advisory committee meeting to all individuals who had requested notice of advisory committee meetings. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting material have been posted on the board's website and are available for review. You may also request a copy of the agenda by sending an email to david.fye at ks.gov with a subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows members of the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office, but as we are after hours, we would recommend that you send an email to bsrb@ks.gov for our record. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda. And the conference call line is active, and I checked it before the meeting, and there's no one currently on the conference call. And Rick, you are currently muted right now.
Thank you. The meeting is now called to order, and the advisory committee will begin with discussion of its first item on the agenda, which is the approval of the agenda. I believe you all received the agenda in the packet of information that David sent out yesterday afternoon. If there's a motion to approve the agenda.
Rick, this is Doug. I move we approve the agenda.
Thank you, Doug. Is there a second?
A second.
Thank you. Was that Rodney?
It is I.
Hi, Rodney.
Hmm.
All in favor? Please.
Aye.
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 Okay, any opposed? Great. Our next item is review and approval of the minutes from our advisory committee meeting on October 11th of 2022. I believe that was also included in your packet that you should have received yesterday. And hopefully you had a chance to review those minutes. Is there a motion to approve the minutes?
So moved.
Okay, is there a second?
I second.
Thank you. And any discussion? All in favor of approving the minutes, please signify.
Aye.
Aye.
Any opposed? And any abstain? Okay. The minutes are approved. So we'll move along to item number 4, which is the executive director's report.
Thank you, Rick. And there have been a few meetings since the last time the advisory committee met, so I'll have quite a few updates for you. But feel free to let me know if you have questions on any of these topics. First, I'll start with some updates from the board's offsite planning meeting. Once a year, the board of the BSRB tries to have an all-day meeting to go ahead and set its legislative agenda and resolve some discussions on items that have been discussed over the course of the year. This year, the board met in Olathe on October 24th and had an all-day meeting. One of the main topics that was discussed, the board has been utilizing an expert witness process for the review of certain applicants. If they went to a program that is not accredited by a national accrediting body, when we have applicants who fall into that category, there are times when we need the assistance of an expert to review the program and sometimes the coursework to determine if the applicant meets the qualifications for licensure based on what's in the statute and regulation. While we have tried to utilize experts here in the state of Kansas, the applicant pool is a little bit larger than the number of experts we've been able to use. And so we talked with the board about perhaps using an outside company to provide some of these reviews and provide opinions to the board on whether someone meets the requirements for licensure based on a review of the information and comparison to the regulations and the statutes. And there is a company called the Center for Credentialing and Education that had presented information to the board in the past and also spoke to the board at the November board meeting. And the board was interested in obtaining additional information from individual agents or states that have worked with that group and possibly looking at RFP language to ensure if they could go forward potentially with an agreement with a company to resolve some of those and shorten the time for certain license reviews. Additionally, when an individual comes before the board and is denied for licensure, they have the opportunity to request a hearing and appeal the decision. The board had currently been utilizing 12 members, all the board members for those license hearings, but to ensure that those can be scheduled a little more quickly and for the efficiency of that process, the board determined that it would start using a hearing panel made up of 5 board members for that hearing process. The 5 board member panels would include a board member licensed in that profession if there was one on the board. Additionally, there would be a public member, and then the other 3 members of those hearing panels could be any members of the board. So in the future, we will be trying to utilize those hearing panels. They do have to be appointed at a board meeting, and then they can be assigned out for some of those hearings that come before the board. Additionally, in other states and for some other agencies, they utilize something called an impaired provider program. These impaired provider programs are used by certain agencies sometimes as a method where practitioners can voluntarily seek services if they are struggling with substance use or mental health concerns, or in other jurisdictions, they are used sometimes as a alternative to other types of disciplinary measures when there's a complaint, but there is also a crossover between those substance use or mental health concerns. And so the board was supportive of exploring utilization of an impaired provider program and is interested in looking at some RFP language to see what companies may be able to provide services to the board under that type of arrangement. Additionally, the board had a discussion about license requirements and reciprocity requirements. Under the reciprocity requirements, the board discussed the main requirements in statute for most of the professions and also recent changes to the reciprocity statutes from a bill that passed last session that involved expedited licensure timeframes for military members, military spouses, and select other individuals. Also, it provided a new method of reciprocity based on if those individuals qualify. And so the board was looking at having additional discussions with the advisory committees about if other items could be looked at for reciprocity requirements to see if additional changes could be made to expedite licensure for certain individuals applying or seeking licensure in Kansas. Also, the board was looking at how to address issues involving workforce. And while a lot of that conversation has been on looking at license requirements and individuals entering the profession, there's also other pieces as part of that equation. One is looking at, is there anything we can do to support existing licensees to help them maintain their license if they are interested in continuing to practice? And then another topic is individuals who had previously been licensed, but their license had expired and they may be interested in reinstating their license and coming back and practicing again in Kansas. And so the board had a discussion about a new proposal that would allow the board to issue a temporary license to individuals wishing to reinstate their license. These would be individuals who have had an expired license for at least a year. So these are individuals who have stopped practicing, and we would be looking to motivate them to come back to start practicing again. So if they had not practiced for a year, essentially the reinstatement fee would be cut in half, and it would be just the normal licensure fee if they wanted to reinstate their license. And then individuals who currently want to reinstate their license have to show that they have continuing education hours for the last license period before they can get their license reinstated. Under this new proposal, they would be able to get a temporary license up to 6 months, so they could begin working while they are obtaining the necessary continuing education hours. And then once they had obtained those hours necessary to reinstate their license, they could have their license converted to a permanent license. So we are looking at creative ways to try to address workforce issues, but also do it in a responsible way. And this is kind of a creative approach that I think will be really helpful in terms of allowing individuals who wish to reinstate their license be able to come back and practice. Additionally, the board recommended 2 changes for the behavior analyst profession. When that profession was added under the BSRB, it was added in a little bit different process than the other professions. It came in with some different statutory language, and there are some differences based on that. The board was supportive of requesting statutory language in a bill this session that would modify KSA 65-7504, which lists disciplinary remedies if individuals have violated the unprofessional conduct regulations or other statutes or regulations of the board. Currently, right now, there's a very limited number of disciplinary remedies the board can utilize, and some of them are very severe. And so the board was supportive of changing that to make it equivalent to the other disciplinary remedies for the other professions. Additionally, there is not a board member identified in statute for the behavior analyst profession, and the board was supportive of requesting statutory language to add a new member to the board, a 13th member, and that would be one for the behavior analyst profession. And if that would be put in statute, then the law would be modified, and then it would be up to the governor's office to appoint a new member of the board for the behavior analyst profession. Additionally, last year we were talking about the topic for social work applicants, individuals who applied while their school was not yet accredited, but was in a process called candidacy. The social work profession or social work field, when a program is seeking accreditation, sometimes that process can take 3 to 3.5 years. And so it's possible for individuals to enter a program while the program is in candidacy for accreditation and graduate from the program and apply for licensure, but the program has not reached candidacy yet, or has not reached accreditation yet. And so some states offer a temporary license to individuals who apply while their program is in candidacy for accreditation. And candidacy means that they are meeting official benchmarks to show that they are on the right track to becoming accredited. And then that temporary license would be available. And then once individuals' programs became accredited, they would be able to have a permanent license under the board. So the board is supportive of creating that new temporary license for those type of applicants. Additionally, the board last year had a discussion on continuing education as it involved a new requirement in diversity, equity, and inclusion and cultural competency. Last year, the licensed psychology profession recommended a new requirement of 3 hours of continuing education in that topic. That was brought before the legislature. The legislature removed that from the bill, so they did not pass it. But this year, the social work profession was supportive of requiring 3 hours of continuing education in diversity, equity, and inclusion or cultural competency. And the board had a discussion about continuing education overall for the professions. And it was noted that while most states, in comparison to the BSRB, have a requirement of 3 hours or so in ethics, the board currently has a requirement of 6 hours in diagnosis and treatment. And that requirement in diagnosis and treatment is a bit unique when comparing our requirements to other states. And so as part of this discussion, the board made a recommendation. To go ahead and reduce the required number of continuing education hours every license period from 6 hours to 3 hours, and to add a new requirement of 3 hours in continuing education under the topic of diversity, equity, inclusion, and cultural competency. And so for those that have the ability to diagnose and have that 6-hour requirement, it would just change the number of hours that they would be assigned to do in diagnosis and treatment, and it would add a new requirement in the DEI topic. And then for those levels of license under the BSRB that are only required to do 3 hours of ethics and do not have the ability to diagnose, it would be a new 3-hour requirement in the DEI and cultural competency area. So that was a recommendation of the board to make it across all professions, all levels of licensure. And so that will be something that will be included in a bill before the legislature this spring. Additionally, there was a discussion about a regulation for the professional counseling profession, and that was KAR 102-3-3A F6. Under that set of education requirements, if someone is seeking a professional counseling degree and did not come from a school accredited by their national accrediting body, KCREP, there are certain requirements they can meet in the regulation to meet the requirements for licensure. So these are non-KCREP applicants. And one of the things that they can do is they can hold a degree either in professional counseling or a related field. However, the requirements in that regulation specify that the person who was chair or directing the program had to hold a doctorate degree in professional counseling. Well, the board recommended changing that to allow the person who is either chair or directing the program to hold a degree, a doctoral degree in professional counseling or another related field matching the type of license the applicants could be receiving. So that will be something that will go through the regulatory process. Additionally, the board last year discussed records of deceased practitioners and abandoned records and was looking for a solution to this. Last year, we were hoping to utilize some of the services of the Attorney General's office and perhaps partner with them. But as we worked through that process, it was revealed that their ability to seize records and perhaps be involved in the custodianship transfer was more limited than we had hoped. And so as an alternative, one thing the board is supportive of is for the professions to look at language under the unprofessional conduct regulations to establish that it would be a responsibility of a practitioner to name another custodian of their records should they pass away unexpectedly or should their records become abandoned. And so the first step the board was supportive of was for it to be added as an unprofessional conduct responsibility. And then after that is put in the regulation, then the board could have individuals, when they renew their license, name the individuals who would be the custodian of the records. And then the BSRB would be able to assist in some of these cases when an individual contacts our office and they either have records that their practitioner has passed away or they have abandoned records. And so, but the first step in the process would be to modify the unprofessional conduct regulations. Additionally, I have some updates from the board meeting on November 14th. The board met and discussed a number of different topics. First, they heard a presentation by a professional counseling multi-state compact representative who was supportive of that compact, that he was from the Kansas Counseling Association. The advisory committee had already received information on that compact, but the board was able to review information, and the board determined that they would take the time between that November meeting and the January meeting to research the counseling compact further, and then perhaps to discuss it further at the January meeting, perhaps taking an opinion on possible legislation on the compact should it come before the legislature this spring. Also, the board is able to appoint an individual to serve on the Kansas Fights Addiction Grant Review Board. In the past, the board had appointed me as the board's representative on that group, but the board was seeking to identify a more permanent appointee, someone who had actual experience treating addictions, and the board identified Jason Hess to serve as the new appointee on behalf of the board on that grant review board. We had opened it up, contacted all the members of the advisory committee, to allow them to provide information if they were interested in serving in that capacity. And a few individuals did go ahead and do that. The board discussed them at the board meeting and appointed Jason Hess. So we're really excited about him serving that role in support of the board. Additionally, the board is not only charged to oversee licensure, but also to investigate complaints against practitioners. There is an investigation policy that guides the work of the board members that participate in that process. That is also called the Complaint Review Committee. That investigation policy was been modified at a few different board meetings this past year and the board made final changes to that document. So a cleaned up version will be presented to the board at the January board meeting. Additionally, the board was supportive of a regulation, which is currently only in the licensed psychology profession. That is KAR 102-1-15G. And that is the regulation that allows licensed psychologists who are coming up upon the renewal deadline, who have not completed all of their continuing education hours. They are able to request extra time to complete those hours while still being able to renew their license. If they can show good cause for needing an extension of time to complete the hours, and if they can provide a plan to complete those hours, they can submit a request to the BSRB. And then we were able to use that this year to allow about 10 to 12 licensed psychologists to be able to stay licensed while completing those hours. The other advisory committees had discussed that, and there was significant support for having similar regulatory language. However, one of the changes to that was the board supported was to shorten the length of time to complete those hours from 6 months to 3 months. Also to change the standard for, instead of showing good cause, instead to show extenuating circumstances. And so we're going to be producing some different regulatory language for the professions, and we will be seeking some statutory authority first in terms of the bill going before the legislature this spring. Additionally, in some of the different professions, they have educational requirements in regulation that requires an in-residence requirement. So if an individual did not attend a program that's accredited by the national accrediting body, some of the professions have language that a certain amount of their coursework had to be received while they were physically present at the institution. But with the growth of online programs and the prevalence of those programs, the board asked the advisory committees to look to see if that was still a necessary requirement in regulation, or if that could be something that could be adjusted if other language would be suitable. And so the addiction counseling, marriage and family therapy, social work, and the professional counseling associations have now all made a recommendation to remove the physical presence component so that the in-residence requirement could be met either physically present at the school in front of core faculty face-to-face, either in person or by screen. And then there have been a couple of recent legislative meetings. There was a joint committee on administrative rules and regulations that Leslie Allen and I attended recently. There are a number of proposed regulations that went through an open meeting process. And we actually had an open meeting here at the BSRB office on November 8th. There was no oral or written comments in terms of those proposed regulatory changes, but those were published in the Kansas Register on December 1st, and they will become effective on December 16th. And we will be sending out a message to all licensees this week just to give them another reminder about those changes that will become permanent on December 16th, 2022. Additionally, there is a legislative committee meeting next week. It is one that has to do with an interim topic dealing with mental health beds. And the chair of that legislative committee is going to be holding a roundtable discussion with certain health licensing boards. And so I'll be attending on behalf of the BSRB. And I believe they want to have a discussion on license requirements and whether agencies in Kansas are pursuing any changes to licensure or reciprocity requirements to address the different topics such as workforce and other issues like that. And then the last item I wanted to make you aware of, this was something that occurred about 2 months ago, but it was after your last meeting. I did attend the annual meeting of the Association of State and Provincial Psychology Boards, ASPPB. They had their annual meeting at the end of October. And two of the main updates from that meeting, one is that the APA is going through the process of looking at accreditation standards for master's level psychology programs. And to be assistive in that process, ASPPB has put together a task force looking at states that currently license master's level psychologists to see if there are some standards that perhaps could be recommended to the APA as they look at establishing accreditation standards for master's level psychology programs. The second had to do with a significant announcement concerning the EPPP. The EPPP is a requirement for licensure in Kansas. And a few years back, they had developed the EPPP2, which they describe as more of a skills-based test, with the EPPP being more of a knowledge-based test. For the last 4 years, I believe, the EPPP2 has been an optional test that states could opt in if they wanted to require the EPPP2, but for other states, it was not required. At the annual meeting back at the end of October, they made an announcement and indicated to states that as of January 1st, 2026, the EPPP would be considered one test with two parts, the EPPP and the EPPP2. They did not put this up for discussion from the jurisdictions. They did not ask us to vote on that measure. It was something that was decided by the board of ASPPB, and they just made an announcement, and they did give us the opportunity to ask questions on that, but that was not something that came before us as jurisdictions to make that determination. And so I did want to make sure that you knew about that. After that was made public, I did make that announcement at the November board meeting as well. But since that occurred after your last advisory committee meeting, I did want to let you know that as well. So the main takeaway from that is they did say that states would be able to opt in early if they chose to do so. But if states want to utilize the EPPP, then by January 1st of 2026, they would need to require both parts if they were going to use the EPPP. So with that, I'll go ahead and end my report, and I can stand for any questions on those topics.
Any questions for David? Thank you, David. That was a lot of information to cover, and
it has been a busy time, but I don't think it'll be slowing down with the legislative session starting. So,
yeah. Okay. So no questions for David right now? Oh,
Yeah,
Rodney's got one.
Yeah. I want to go back to that because I'm just about how my mind works, kind of warped. The unprofessional conduct, not specifying a delegate. I'm wondering how that works, because typically when you make an allegation of unprofessional conduct, the person may be dead at this point. I mean, really, for this to take hold. That was the first thing that went to my mind. Like, how does that work?
So I think the idea was to first put a spotlight on the topic so that practitioners are aware it's their responsibility, and to add more visibility to it and more attention so that individuals would be mindful to do it as part of their responsibilities as a professional. On the renewal application, once it is something that's a practitioner responsibility, we would have the ability to ask questions about that to ensure that they are, or at least to provide some accountability to check to see if they do have a custodian of their records identified. This is an issue that we only see maybe a couple times a year, but we wanted to be assistive in this process. One of the tricky things is, so the Board of Healing Arts, they have an actual statute that deals with passage of records in terms of custodianship, but they're a much larger agency and they have a dedicated fund specifically for that purpose. And so we simply lack the resources to take a very active role in this process, but we wanted to be helpful. And so I think part of it is just kind of making sure practitioners know that it's their responsibility. You do bring up a good point. If a practitioner does pass away, what is the recourse? I think one thing could be, this could be deceased records or practitioner records, but it also could be records that became abandoned. And if the person has left, I suppose one of the things that was discussed is that we would be able to do a report of alleged violation potentially, and then this could be something that would need to be resolved should they wish to practice in the future. So there would be some extra accountability as that goes. But really, we're just trying to start a process of being supportive and being helpful in this process, while also not trying to overcommit resources that at the moment we just kind of lack in this area.
Understood.
So in my thoughts on it, Rodney, are that the real importance of this is the renewal, right? So that we're all called to identify those recipients of the record when we renew. And you're right. Once I'm dead, you guys can't touch me, which is fantastic news for me, really. But
I don't want to spend much time inside of that thought.
But yeah, that's a different board.
Yes, exactly.
Yeah. So to me, the value is getting psychologists to be aware of this and to do something about it. and the unprofessional conduct we could address at the time of renewal.
Well, no, and
yeah.
you're preaching to the choir. I'm just thinking functionally
Yeah.
how does this work? Because really,
Yeah.
to violate that unprofessional conduct aspect, one has to have died and then
Yeah.
find that the person that you designated isn't really in existence, or you fail to have someone designated, which is highly unlikely. It's more likely that you're going to have someone who's going to designate someone, and then only after that person is dead are you going to find out that that's kind of a dead end road, no pun intended. So that's what I was thinking from a functional viewpoint. How does this really work? I think you can get people to designate a body. Its question is whether or not it's a credible body, and you won't really find that out until the person is dead.
That's true.
Yeah, I think the main thing is to try to put a spotlight on it
Yeah.
and to make people think about it. And I think most people will do the right thing, identify someone, as opposed to right now where some people may not be considering this or maybe treating it as a best practice as opposed to something that would be a normal responsibility. So.
Any other comments or questions on the director's report? Well, then we can move on to item number 5, which would be an update. 5A would be an update on SIPAC Commission activities. David, I think that's you again.
Okay. Yes, and so I like to provide an update in terms of the number of individuals who are practicing under SIPAC authority. Now, as far as individuals who are practicing in Kansas, it's hard to really identify that number because individuals under SIPAC are not required to say that they're practicing in specific states. But what we can track is we can track the number of individuals who have a home state license that is a Kansas license, and those people are licensed as licensed psychologists in Kansas. And so currently, the number of individuals who are licensed psychologists in Kansas with their home state license in Kansas, practicing under telehealth services, that is the authorization to practice interjurisdictional telepsychology holders, or the individuals who hold the APITs. There are currently 74 of those individuals. And then the other option you can pursue is something called the TAP. That's the temporary authorization to practice. Individuals who hold a licensed psychology license here in Kansas that are utilizing the ability to practice limited days of in-state services in other compact states by using that TAP is there's 7 individuals. So currently there's less than 100 individuals, but that number is growing. And so I'll keep updating you in terms of the number of individuals who are practicing under SIPAC authority. Currently, there are, I believe, 33 states that have passed legislation on SIPAC, and I think 32 of those are active. Probably at the beginning of the year, that'll reach 33 states that have active membership in SIPAC. So while it is not all states, it is definitely the majority of states at this point. And so I'll keep an eye on this as the commissioner of SIPAC. I'll try to give you guys updates in terms of any other information. And there's a quarterly newsletter that I try to provide about every other meeting. So I'll make sure to keep you updated on any changes in SIPAC. Now in January, we will see the first assessment to the state of Kansas. That as SIPAC was passed, one of the items that was discussed was that for each individual who is licensed list Kansas as their home state, the SIPAC Commission will look back at the end of the calendar year and will assess the state of Kansas $10 for every person who's practicing under SIPAC authority. So it would probably be a little under $1,000 this year. And then it's an annual charge. So we'll probably see somewhere around that unless there's a significant growth in SIPAC. We'll see that at the end of next year as well. Now, the board did approve a fee for individuals who are practicing under SIPAC authority. The first time that will probably be realized will be when individuals renew their license as licensed psychologist in 2024, but that approval for that fee is going through the regulatory process right now. So we're still waiting for that to go through, and then it'll have to go through an open comment time period. And so it'll be a little bit of time before we see that fee, but that fee was intended to help balance out the assessments the state of Kansas will receive in terms of some of that expense that we will have to pay because of those assessments. So.
Okay, any questions about SIPAC? Great. So item 5B may take a couple of minutes. As you all know, we've spent the better part of this year looking at the unprofessional conduct regulations for the profession. And I think we have reached the end of that process. David is going to share his screen in a second and show us a marked up draft of KAR 102, 102-1-10A with the recommendations that we have made over the past, I don't know. Did we start this in February? It feels like we started it.
I think I think we discussed it in February and may have started it either in February or definitely by April.
So just one thing I would note is you may recall back toward in the spring, I believe, one of the recommendations we made that I think will be reflected here is moving the record keeping regulation into unprofessional conduct. And so that was kind of that'll be a major deal for someone. And then with that, do you want to walk us through these, David, or do you want?
Sure, I can walk you through this. So what I did is I went back through the minutes from the different meetings where the unprofessional conduct regulations were discussed. And there were certain items that were highlighted, certain items that were discussed, and the advisory committee was supportive of certain changes. So I thought what I would do would be to go through your list of potential changes to the regulation. And if there's still consensus, then what we could do is have these proposed changes forwarded to the board so that they could see the changes from the licensed psychology profession. And so what I've done with all the other advisory committees so far has just been to create a table like this. So on the left is the wording of the current regulation, and then on the right is some comments or some proposed language changes. And so we can kind of walk through these. The first one, as you mentioned, there was a separate regulation on unprofessional conduct related to record keeping. There was the overall comment that the advisory committee was supportive of combining this into the main unprofessional conduct regulation. There was also support for adding language that a practitioner should have a policy for transferring custodianship of client records to another responsible party in the event of practitioner's unexpected death. But there was not an official recommendation. But then there was a comment that in section C of the record keeping regulation, you could add language requiring the next custodian of records to be named. And then other language could be included in the unprofessional conduct regulation, noting that it would be unprofessional conduct to fail to fulfill this requirement. And the advisory committee proposed considering adding the following language: failing to identify a repository for client records should the psychologist become incapacitated or unable to access their records. And so on the left, I don't have the full 102-1-20, but the discussion about where to include that language was underneath C for the most part. And so I thought I would double check with all of you to see if you were still supportive of those changes, to go ahead and combine it with the main unprofessional conduct regulation, and also to add the language there about it being the practitioner's responsibility to identify another custodian of their records.
David, can we do these by consensus? And then if we need a vote on them as a group at the end?
Sure. And, one thing that we could do just for efficiency is that, absent objections, it would be interpreted as the consensus of the advisory committee. And then if someone has an objection, they can go ahead and voice other thoughts.
That would be perfect. Thank you.
Great.
I have a question. So that language would be inserted as C3, the quote. The failing to identify a repository, would that be under C point 3?
Yeah, and I think we would have to modify the language a little bit to be consistent. The main unprofessional conduct regulation essentially says it would be unprofessional conduct to do the following acts. And so we'd have to modify this language to kind of fit that. But yes, that would be the idea, would be that similar language, failing to identify a repository for client records should the psychologist become incapacitated or unable to access their records. That would be essentially a new item 3 under this, once it was brought over into the main unprofessional conduct regulations.
Okay.
Yeah, I suspect that all the numbers are going to, because it's moving from one regulation to another. I think the current lettering system may shift substantially, but that would be the general place it would go.
Mhm.
Okay.
All right.
Sounds like there's consensus on that. Okay. The next item is KAR 102-1-10A. And there was item C and item D that were discussed. C talks about engaging in harmful dual relationships. D talks about making sexual advances towards or engaging in physical intimacies or sexual activities with or exercising undue influence over any person who within the past 24 months has been a client. And so the advisory committee members discussed the difference between these two and discussed whether item A, because it does talk about, so I guess there's a little bit of an overlap between these two. Under C, it talked about engaging in harmful dual relationships, which shall include the following acts: making sexual advances towards or engaging in physical intimacies or sexual activities with either of the following: any person who is a client or any person that the client licensee knows who has a significant relationship with the client, supervisee, or student. And then the other item talks about a different topic. But yes, there was a conversation about whether A should include reference to supervisees and students. And it was the consensus of the advisory committee to add a reference to supervisee and student in KAR 102-1-10A C1A. So that would mean it would be unprofessional conduct to make sexual advances towards or engage in physical intimacies or sexual activities with either of the following: any person who is a client, student, or supervisee. So that's kind of how that new language would read under that.
Yeah.
Okay. Then if there's consensus on that, I'll go ahead and move to the next, which is KAR 102-1-10AE, and that deals with failing to obtain informed consent. The advisory committee discussed the topic of informed consent as related to forensic examinations and expressed general support for adding a new item 4, considering several phrasings such as failing to inform the client of the limit of a professional relationship and the requirements imposed by other parties, failing to inform clients when a third party is the client, or failing to inform clients when a provider's ability to maintain privacy or confidentiality is compromised by a third party. So I think one thing that you could talk about tonight is maybe if you prefer one of those 3 phrasings as a proposed change to the regulation as a new item number 4.
So one of the issues here, and I think Rodney may have been one of the folks who brought this one up in particular, maybe it was other people. It's if you're doing a forensic evaluation on, for example, someone who's incarcerated at the behest of the court, that person may or may not have full informed consent and may not have entire control over what happens with their records. It would be unprofessional not to inform that person of your ability to maintain privacy or confidentiality because of your relationship with the court.
And I would go further. My concern is not so much people being imprisoned, because I don't really deal too much with the population. It's the people who have been court ordered to do an evaluation for parenting purposes, what have you, not letting those people know that they are not they're not your client, and that your duty of confidentiality to them is fairly limited, if at all.
Right. And we did talk about that. In the eyes of the state of Kansas, they are your client because you are performing an act on them, right? The problem becomes that the person who's paying you is the state of Kansas or the court or whomever.
No,
right?
no, it's actually a little bit less cumbersome than that. The person who's paying me is often the person who's right in front of me. but it's the fact that they're not exercising free will, which is what I've always had an issue with, because they're being compelled by an external body under threat, implicit threat of duress. You know, something bad's going to happen to you if you don't go do this. So it makes the court the patient in my world. But the money never comes from the court.
Sure.
Does that make sense?
I completely understand what you're saying, and I still say that in the eyes of the regulations, the person who is taking the test is technically the client, even though you're providing the information to some other third party.
Right.
So I think, in my opinion, and this is only my opinion, the final quote, the last one that appears in that cell, seems to capture everything that, Rodney, you're talking about.
Okay, I want to be careful about this because I don't want to get undone here in the doing of this. If someone's going to go after me, and they generally do, is when I'm involved with court order cases, it comes up, this is the issue. Who's really the client? And I've danced before the BSRB on this question before. And oftentimes, I don't know, it's because of the way I do informed consent, I make a big to-do about saying, you're not it. You know, the court sent you here, and therefore, as far as I'm concerned, the court is the client. And therefore, if you want to get access to things that a client might get access to, that would be entitled to you under the doctor-patient relationship, legal responsibility, you will have to go back to the court and get a court order, because as far as I'm concerned, they are the patient, they own the medical record, and therefore you need to ask their permission to get access to their record. And I understand what you're saying, Rick, but that's not how the game, I don't think it gets played in a real sense.
Certainly. The other part of that is also true is that you would feel probably unethical to go discuss that person's record with the general public.
Oh God, yes. Yes.
Right? Which means that they are under some sort of client-patient privilege with you, because you're not going to tell me about that assessment without someone's permission.
Right, but the client still is the court. The reason why I would feel unethical is because I would be betraying my client's confidence, which is the court. I can't go out and talk about the court's business without the court's say so. So we may be talking semantics, but yes, there is a duty. It's just that we're in a disagreement about who that duty belongs to.
So are you not comfortable with one of the three quotes that are in this box?
Oh, I would say, I just want to make sure we're talking about the same thing. I'd say failing to inform a client when a third party is the client would be the one I would go for.
So that would be the second one here, failing to inform clients when a third party is the client.
Yep. We don't have a way of saying anything other than client. Two clients here. Now you could change that to failing to inform the person under evaluation that a third party is the client.
So I'm thinking about this. This is actually a little bit different. I'm thinking about the people with whom I work who have workers' compensation insurance, and workers' comp is the entity that's paying, and they have rights to the records. Even and the person who's sitting in front of me is the client. But they don't have, there's a gray area as to exactly what they can and cannot do in terms of accessing or having control over their care. And that is where the word client, where I see where both of you are coming from. I would be fine with the second one. I'm just kind of thinking this through as we're talking about it as to what would most appropriately fit a an array of situations, but this is really tailored or really kind of centered on forensic examinations, which are definitely their own sort of category when it comes to informed consent.
I feel more inclined, but to the first one, because to me, that kind of reads also informing the person of the scope.
Ah,
It may also be a little, it's a little bit more descriptive in what you're having to inform the person,
agree. Yeah.
right? Because number two, for me to tell my client or this person that I'm seeing for professional services that they're not my client could be very confusing. And then I've met the letter of the law, but not the spirit of the law. But if I do number one, that may, yeah, does that?
Yeah, I can make that work because
Okay.
I think that it's less rigid than the second,
Okay.
and we can fit a lot more into that. I just don't want to change statute in such a way that protection, in a sense, it's not muddied.
Yeah.
Yeah, I tend to agree. I like number one the best because it really gets at the heart of you're explaining the limits of confidentiality in a way for them and the limits of that relationship in general. So I prefer the first quote.
Okay. Are we in general agreement?
I can go with that. I think that for some people, I'm reading the word requirements imposed, and it took me a couple of moments to digest that to get what it meant. And I do see what that particular phrase means. I think that some people, and maybe I'm just a little bit slow on the uptake tonight, but that phrase may catch some people up in terms of what does it mean by requirements imposed by other parties. Well, that means that the court has these requirements of being able to extract information or get information from the evaluation that's being performed. And the psychologist has to in turn tell the patient that the court has to have access to this information.
Yeah, which I was going to make a comment. Something that you described earlier when you were talking about your point of view on this dealing with disability. That really isn't too unlike dealing with just a general third-party payer like an insurance company. The same rules attach. You know, if you come in the door with Blue Cross and Blue Shield and you're getting therapeutic services, Blue Cross Blue Shield can ask for your records any day of the week, and there's nothing your patient really can do about that because it's part of their agreement for getting those services paid for by Blue Cross Blue Shield. Sometimes it's a little bit difficult for people to understand that they can't really stand in the way of that. And they've signed off on it somewhere along the path that they were okay with it. But yeah, definitely the case.
So where are we with this one? We need a one.
I'm good. I'm good with it. I'm good with number one.
Okay.
I think number one, unless
Okay.
there's disagreement.
Okay.
And Rick, Jessica Hamilton, I believe, just entered the meeting. So she's
great.
here.
Yep, I'm here. Sorry I was late.
Thanks for being here, Jessica.
So just for clarification, do you think it would be helpful to have language that says when involving a forensic examination, failing to inform the client of the limit of a professional relationship and the requirements imposed by other parties?
I don't know if you have to be that specific.
Yeah, I think that there could be other scenarios in which this may be true.
Okay. But number one, the failing to inform the client, that's the language that would be recommended.
I think that's what I heard.
Yeah.
Okay.
Okay.
There you go. Okay.
Looks good. Okay.
All right, so the next item would be KAR 102-1-10AG, and this has to do with failing to protect confidentiality. The advisory committee members discussed that the language in item G, specifically 3A, we can go down to that here in a second, may need to be revised as current telehealth involve electronic devices, but does not necessarily include recording of these sessions. It was noted that these regulations include language protecting confidentiality, but it was discussed whether additional language should be added concerning privacy. Advisory committee members expressed support for adding language that a practitioner should protect a client's confidentiality and privacy. Support was noted under item 3A to include whether the session was being recorded. So item 3 is failing to obtain written informed consent from each client or the client's legal representative or representatives, or from any other participant before performing any of the following actions: electronically recording sessions with a client or other participants, including audio and video recordings, or B, permitting third-party observation of the activities of the client or participant.
David,
Yes.
Kansas law. I'm going to ask a question here. I believe it's legal in Kansas for you to tape anybody as long as you are a part of that conversation, and you do not have to disclose to them that you are taping them.
So this is not my legal opinion. I believe what I have heard is that there are different states that require both parties to be informed when there is recording. What I have heard is that I believe that Kansas is a state that as long as one party knows there is recording, that is sufficient, because that's where the states draw a line. And so I believe Kansas is in that group of states where as long as one party knows the recording is happening, then that is acceptable in certain ways. That's what I have heard, but I do not know that for a fact. So.
Well, I do.
Okay.
Because I get caught with that one as well. This, this is what folks will do. They'll walk into your office, and it's happened to me a countless times. So, the trick is don't say anything you don't have recorded, but they will record you and they won't let you know. And the first time you'll find out that they've done it is they'll present it in some type of court proceeding to try to trip you up, or they will make allusion to it in their complaint to the BSRB. Now, this is becoming a little bit of an interesting place because I just went to a conference where they're now introducing into this discussion for clinicians that we need to be a little bit more cautious about even taking that as validation of something occurring, because people can now alter these mediums and make them say whatever they want them to say. So it's kind of sticky, but yes, in the state of Kansas, anybody can tape you and they don't have to tell you.
Does that actually impact our decision to include privacy, and that we would be letting the patient know that we would be recording a session if that was something that we felt was necessary or important?
Right.
Regardless of the legality. I think from my perspective, maybe I should work. I mean, I don't have maybe patients are taping our sessions, but if I was recording for whatever reason, that I still feel like I would want to make sure that I had that patient's permission.
Yeah. Right. So regardless of what's legal for me to do, there are some things that are professionally
Unethical for me to do.
unethical. And this regulation seems to be focusing on the ethics, right? Not the legality of many things, because it is the unprofessional conduct, not the illegal things not to do.
Okay, so let's play with that for a little bit. Let's say I've got camera equipment in my facility, but it's not necessarily in the room with my patient. Do I then have a duty to disclose that to them if it's part of just general security and surveillance? And if I do disclose it, is it okay if I disclose it within the context of my informed consent form? Does that satisfy this requirement? I like that look on your face, Rick. It's like a vapor lock.
So the way the regulation is currently written, it is unprofessional to fail to obtain written informed consent when you are electronically recording sessions with the client. So if you're contemplating whether they're in your waiting room and on a security camera, I would say that falls outside of this current regulation.
Okay.
Well, and Rick, under this item, it's really targeted towards failing to protect confidentiality,
Right,
which shall include the following acts. So the confidentiality piece really is the first piece.
yeah, nothing happens in the waiting room that is confidential because there's other people there that are not in the the attorney-client privilege. Yeah, that,
And this would not apply to a person who wasn't your client.
right. Right. So then the question is, so I remember I've got some notes on this one. The concerns were specifically around telehealth and recognizing that confidentiality and privacy need to be protected regardless of whether recording is happening. So if I'm doing a Zoom session with a client and I'm in the roller skating rink without earphones on, and so people can see my screen, that would not be addressed here, but probably should be. Right? Is that, am I remembering this one correctly, or is that a different place?
I think that was part of this conversation. Because I think that there was also a comment made during one of the meetings about, it would be helpful if there was specific telehealth standards between the professions on a topic like this.
Yeah.
And I'm not sure if any of the other advisory committees really discussed that, unfortunately.
Okay. Can you scroll back up just a hair? I'm just missing. Yeah, there we go. Thanks. I just wanted to see that first.
So this is because I had not been appointed, I think, when this discussion was had. So it sounds like there are two matters that are being called upon. One has to do with confidentiality generally when it's transmitted, when there's a session that's going on and it's done via an electronic media. And there's also a second matter that has to do with confidentiality and having safeguards around it when a session is being recorded. Am I interpreting this correctly?
I believe so. I'm trying to look at two different sets of my notes here from so what I see on the spreadsheet here is specifically so I'm wondering about it, just whether it just is much more general, right? So these regulations should include language protecting confidentiality, but it was discussed whether additional language should be added concerning privacy, right? And so if that's under right, so David, you've identified that as item 3A. But I'm wondering if that line there is discussed whether additional language should be added concerning privacy isn't at all the way up there at G before it gets to 1, failing to protect confidentiality and the client's privacy. And then does that seem, Because there's an umbrella privacy thing that isn't really, I mean, our statute recognizes confidentiality here, but it seems to fail to contemplate privacy as a separate thing from confidentiality. And so I'm wondering if we go back up to G, before we get to G1, failing to protect confidentiality and client privacy.
Yeah, that may be the best place to put it, since it seems like all of these could involve not just the confidentiality, but also the privacy.
Right. And then so David, if we say that failing to protect privacy and confidentiality, which shall include the following, is that when you say which shall include, does that mean that all of the examples are provided, or does that mean some examples are provided? Do you understand what I mean? There are other ways to fail to protect privacy that might not be listed here. I'm just trying to figure out if we need to include specifically failure to take appropriate steps to protect private, that says the same thing as saying failing to protect privacy and confidentiality.
Yeah, I would say, so it has items 1, 2, and then 3.
Right.
The unfortunate thing is the inclusion of the word "and" here after 2D.
Yeah.
So it really probably should be an "or," so that it would be 1 or
Right.
2 or 3.
Yeah. Well, that seems like the lowest hanging fruit. So I would recommend changing "and" to "or."
And then perhaps maybe in that first line, as far as failing to protect confidentiality, which shall include the following acts: failing to protect confidentiality and privacy.
Yeah, I think in that first line, I think I would like to see privacy in there.
Yeah, I think that kind of goes towards the comments that were made previously, and that would help. I don't believe it was intended to be 1
Right.
and 2 and 3. So
Right. And I think that addresses the 3A problem, because the 3A problem that we originally talked about was if I'm doing telehealth and I'm not recording, I could still be violating someone's privacy. If I'm doing therapy right here with all of you and someone is in the room with me, right? That would be an obvious violation of privacy and confidentiality.
So it would be an edit of G1 is what you just said, and it would be adding. So it would be like failing to inform each client, ... and adding something to the effect of failing to maintain privacy. Did I hear that correctly?
Yeah, I'm putting it up there before 1 though. If I were going to put it in here, I would put right when it says KAR 102-1-10AG, failing to protect confidentiality and privacy, or some permutation of that.
I did hear that. I thought it was going to be an elaboration on that in one of the points
Yeah.
up under it.
Mhm.
Well, and Rick, probably let me know if you disagree, but under the top line, failing to protect confidentiality or privacy,
Mhm.
as opposed to and privacy, because it could be one or the other. So
I think or is better. And Richard, the question I had is, if we said that, do we have to have a specific
Yes.
A, B, or C, or 1, 2, or 3 below to enumerate how that's done beyond what we have? So that's my question. And I don't think I would like it would be nice if we had an attorney to help us with that one. To think through if we need a specific example, or if that umbrella clause is enough to address that.
Could the shall clause this is gonna this sentence is not gonna come out very well. Could the shall clause include but not limited to the following acts?
Yeah, I've wondered about that's a good idea. Does that work?
sorry,
Is-
say that again. Could you repeat that?
So could the shall clause include, quote, include but not limited to, end quote, the following acts?
Yeah. So shall include, but is not limited to the following acts.
Yeah.
Yes.
Do we do that in regulations?
Yes.
Okay.
Yeah.
I think that helps.
Yeah, because there was another one that was discussed. It might have been for other professions, but it was discussing advertising and billing practices, but it was talking about essentially professional conduct. And then it said those two, but it was not intended to be only those two. And those were just two examples that were highlighted. And so there was some clarifying language similar to this. And so
Okay.
so I think that would address the different items. So it would say failing to protect confidentiality or privacy, which shall include but is not limited to the following acts.
Yes.
And then we'd have item 1, item 2, and then it would replace this and at the end of item 2 with an or, so that it could be 1 or 2 or 3.
And D needs to be relabeled as C, doesn't it?
No, there's a C up there.
Yeah, C is up here. I think it might have just been a formatting issue.
Oh, okay. Thank you.
Yeah. Okay, I don't want to open a can of worms, but if there was a 4, it might include something like failure to take adequate steps to protect privacy in the electronic environment, or something like that. We had been given a little bit of a mandate to address telehealth. We had kind of been told to do that, and the only thing we have does that just make it muddier, or does that make it less muddy?
What does adequate mean?
Yeah, you're right.
I mean, some of that flexibility is helpful, though. I know it is difficult to know exactly where you fall, but sometimes there's different fact patterns are different based on different scenarios, and sometimes it can be helpful to be able to look at everything to make that determination.
Well, if it's not needed, then we can just strike that suggestion.
And one thing that is going to happen is, so we're going through these unprofessional conduct recommendation changes with each profession, and then the list of these will be forwarded to the board. And so at that time, the board will be able to see all the recommended changes for each of the professions. Some of the advisory committees are still finalizing theirs, so I think it's likely that the board will definitely not be able to act upon them at the January meeting, but we'll receive the ones that are ready at that time and then receive additional ones probably at the March meeting. And so there probably will be some interest in the board having perhaps some uniformity if there can be similar language. And so anything we can submit at this point would be helpful, but it doesn't have to be the only time that we go back and look at some of these.
Okay. So are we happy with those changes, adding privacy in the front, changing or? Oh, you already got them. Okay, you got, no, there's more. No, you haven't. So after D.
Yeah, I haven't modified this language over here on the left, but adding it so that it's confidentiality or privacy on this first line, which shall include but is not limited to, and then changing after item D, changing the and to an or.
Okay.
So that 3 will be 1, 2, and 3 will be standalone items. So.
Okay.
That's good.
And we can move next to KAR 102-1-10AL, aiding in illegal practice, which shall include certain acts here. Under L2, replacing the word credentialed with another term reflecting current terminology by which the board authorizes practice. So under L2, it was knowingly aiding or abetting anyone who is not credentialed by the board to represent that individual as a person credentialed by the board. So I wanted to suggest to you perhaps instead of the word credentialed, maybe authorized to practice. So knowingly aiding or abetting anyone who is not authorized to practice by the board to represent that person as a person authorized to practice by the board. Would that be helpful in terms of replacing just the word credentialed with something that is more suitable to what we currently use in terms of authorized in practice?
That makes sense to me.
Okay. Most of the individuals have a license, whether it's a temporary license or a permanent license, but we do provide some temporary out-of-state permits. And so I think authorized to practice would be something that would cover the umbrella for those individuals.
David, does the board credential or does the state credential?
So the way that the term credentialing, what I have heard recently is credentialing done by insurance panels, mainly involving different payments. The board right now, licenses and then issues permits. And so but there are, there's different terminology used in different jurisdictions in terms of what they use in place of license, like license registration. Some of that has to do with individuals from other jurisdictions outside the United States, which might use some terminology there. So we don't currently use the term credentialed in terms of our day-to-day operations, but I have heard it more in terms of billing and credentialed by insurance panels. But I think just using a broad term like authorized to practice covers our current methodology. And then should we create something new, we wouldn't have to go back in here and change it for that purpose too. So it sounds like there's consensus on this item.
Sure.
Okay. The next one is KAR 102-1-10AM. It's failing to maintain and retain records as outlined in the regulation, which had to do with unprofessional conduct involving record keeping. So this one would just be replaced by bringing in the unprofessional conduct regulation involving record keeping. So this essentially would be replaced by that, bringing it over. KAR 102-1-10AN talks about improperly engaging in research with human subjects, which involves 4 different things that were identified under N3. The advisory committee suggested replacing language, the consent of a participant, with the consent of a participant or the assent of a minor participant. So it'd be just adding some additional language to clarify what should be done in cases of a minor participant.
So I think that or might need to be I think we need to add consent of a participant or the participant's representative. Right, because as a parent, I can give consent for my kid. And that's required. And so it's not an or, I think it's an and, right? Because even if my kid agrees to be in the study, it is not okay unless I have provided consent, right? So I would say consent of a participant or the participant's representative.
Can we use the word guardian? Or should we be using the word guardian instead of representative?
I don't have an opinion on that.
When I'm thinking about situations where that might not be true, like if a kid is in SRS custody, they still are the guardian of the child, so that still fits.
Does guardian have the legal? David that's fine with me. I think our guardian is fine.
And David, you may have to answer this. I think guardian has more legal weight when it comes to this sort of thing than representative. Representative sounds like their attorney.
Yeah, I'm honestly not sure. I'm not sure I have a lot of knowledge on the term guardian.
Okay.
And Richard, I did see, I thought you were about to make a comment, so I didn't want to give you the opportunity if you had to.
No, I was nodding in agreement that we could substitute the word guardian in for representative.
So up in G, we just covered G, D. No, sorry, G3, failing to obtain written informed consent from each client or the client's legal representative or representatives or from any other. So I think representative is what's used in this regulation when it's referring to someone who has the authority to
Act on their behalf.
Yeah, guardian is not used in this statute or in this regulation ever.
Looks like the use of the term representative or legal representatives would be consistent with G.
Yeah.
So Rick, remind me again the proposed language that you were discussing.
Consent of a participant or the participant's representative. Comma, and so that's replacing in 3, replace language consent. So it would read failing to ascertain that the consent failing to ascertain I'm having a hard time substituting either because it looks like the only thing that was getting replaced is the consent of a participant, and consent of participant in N3 is in the midst of failing to ascertain that the consent of the participant is voluntary and informed.
The clauses may need to be numbered. So failing to ascertain that the one, the consent of the participant, comma, or or the participant's representative, and 2, assent of a minor's participant
Is voluntary and
is
informed.
voluntary.
Okay. Yeah, and then put the 2.
No, the 2 would,
Yeah, the 2 goes right before or right after and, I think.
yeah, the 2 goes after and.
That's how I was hearing you say it, Richard.
Yeah, the 2, yep.
So does that work in context? So failing to ascertain that the consent of the participant or participant's representative, and 2, the assent of a minor participant is informed.
It's voluntary and
It's
informed.
voluntary and informed. I think that works for me. Does that work for folks?
Does for me.
Okay,
Sounds like there's support.
okay.
And then the last item, this is KAR 102-1-10AO, and that was engaging in improprieties with respect to forensic practice, which shall include the following acts. So under O1, replace language when conducting a forensic examination, failing to inform the examinee about the purpose of the examination and the difference between a forensic examination and a therapeutic relationship, with instead using the language when conducting a forensic examination, failing to inform the examinee of the purpose of the examination, the difference between a forensic examination and a therapeutic relationship, and informing them of the scope of the assessment procedure. So it would just be additional language added on to the end and informing them of the scope of the assessment procedure.
Okay, so it's failing to inform the examinee of the difference and failing to inform them of the scope of the assessment procedure.
How do I satisfy that last part? The scope of the procedure?
Yeah, the new proposed language would be in informing them of the scope of the assessment procedure.
So again, how do I do that?
Rodney, my little notes say that I think the issue here was, it may have been something you brought up that,
Oh God, I hate it when that happens.
I know, don't you? It may have been that there are certain, basically the client not knowing that certain things that they are doing are actually being recorded and are part of the assessment.
It's not, hey, I came in for a parenting assessment and then they took my kids away from me. You didn't tell me that that was possible, that they could take my kids away.
Well, you probably didn't take the kids away.
Well, yeah, but it doesn't mean I'm not going to get blamed for it.
Well, right, but I think it's the scope of what, so if the assessment procedure, so they've done the WISC and they've done the Woodcock-Johnson and they've done whatever other test you wanted to do, but
Right.
what they didn't know is that you were counting the number of times that they pulled their hair, or whatever.
Or
or,
Or they did those things and kind of like on the way to the market, I saw a murder, but I was
Yeah.
only supposed to go get bread. So you do have to talk about the murder you saw. So in the course of doing all those things, if you start whacking out professional term, and I sense that you have a personality disorder, like you're borderline, well, I'm going to talk about the implications of that when it comes to child rearing. And because of that, depending on how extreme you are, and I'm actually thinking about a person as I speak, that could lose to you. That could lead to you actually losing access to your kids or having supervised visitation as a consequence. Now, was custody of the children part of my mandate? Maybe not. But again, on the way to the market, I saw a murder. So, I mean, is that acting outside of this if I don't inform that? Well, one of the consequences of you doing this is that you may or may not lose your kids, but I won't have anything to do with it.
Can I add something? Because I brought that up with the setting that I work in.
okay,
I'm on a unit. I may not be that unit's psychologist, but in doing the competency evaluation, I'm going to inform the client or the patient that other staff observations on the unit are going to be taken into account. You know, I'm looking through notes, the therapist notes, group notes, all of that stuff to inform my evaluation. So all of that stuff will be included. Whereas they might think in a typical, you know, way that just what we are,
right.
just the assessment itself is what, you know,
Yeah.
is the evaluation.
So if I didn't tell you, Tiffany, this thing, then I don't think you should be able to use it. Right. So you observed it or you read it in my, you know, someone else's notes.
Mhm.
That's what this is trying to take care of is
Yeah.
those additional assessment procedures that the client might not think is important that
Yes.
could have been important. Which, Rodney, I think gets to your comment about the personality disorder situation, right? Your observations of those behaviors are part of the scope of the assessment, right? You observed that this person is demonstrating traits that are consistent with a particular diagnosis, even though that wasn't really on the WISC.
Right, exactly. And I'm going to go and join Tiffany here because I'm going to give a cleaner example. Let's say, and this has happened before as well, while I'm in talking to someone, maybe their kid, I notice that they're out, my receptionist notices that they're sitting in the waiting room with the kid I'm going to see, and the mother is completely on the cell phone the whole time while the kid destroys my lobby and does nothing in the process. That could be reported back to me and show up as part of their evaluation. Although it wasn't something that I directly saw, it was one of my staff saw, but I think it's no less relevant. It's kind of like what Tiffany is saying.
Mhm.
It's somebody else around you. Really, I should be telling people, you know, from the moment, and which is how I do business, from the moment you pick up a phone and call my office to the moment I send in that report, you're doing your evaluation. So any contact with me or my subordinates, it's fair game. I don't say that, but that's how I practice.
So I think this would be saying that you need to say that.
I need to say that.
I think that's what, if we make this change to the recommendation, to the regulation, then this would say, Rodney, yeah, you need to tell the client, and Tiffany and Rick, you know, you need to tell the client that your informal observations will also be used in this evaluation, including the murder that you keep seeing on the way to get the bread, Rodney. You need to pick a different place to go get bread because, dude, I mean, you know.
I travel in a rough neighborhood, man. Deal with it.
Okay, are we comfortable then with scope of the assessment procedures?
Yeah, because now you've just told me how I do that.
Yeah, and I think it's, I think I would add the plural to procedure. I think it's procedures, if that's okay. Okay, Are we there?
That's the last one.
Can we
So
put the lid on this one?
I will save it, but we're not done with the meeting, but thank you all
Oh.
for all of your work on this. I know that you have spent a lot of time looking at the regulations and put a lot of thought into these recommended changes, and I think they'll be very helpful. So very big thank you.
Yeah, those look good. Yay, we did that. That was our big thing that we did in 2022. So if anyone asks you what you did in 2022, that's what we did. So yay. Don't you love being able to get to the end of something and you look back and you think, what did I do? I was so busy and I don't know that I did anything. And so now you did something. So that's,
Yeah, and I think it's really important to reference again, the last time that these unprofessional conduct regulations were modified was 2004. So it's been a good 18 years, but
yeah.
appreciate all your hard work this year. So
Okay. So it's 7:38 and we are down to item number 6, new business. And so we will at least mention all of these. We have a discussion of reciprocity and other requirements for licensure. And this is, this was a request made by the board to the committees, I believe, to help us look at those reciprocity issues, to kind of the workforce issues. I don't think that there's a mandate for us to change anything, but the mandate was for us to look at the reciprocity statute and the educational requirements to make sure that we're comfortable with having those requirements remaining in place as they are. Is that correct, David?
you are correct. Yes, there's a pretty consistent statute on reciprocity for most of the professions. And it talks about for the psychology profession, it's 74-5315. And it basically states that the main way that individuals can be licensed in Kansas by reciprocity. I'll go ahead and I'll share that document, but it says that there are two main ways. One is, did they come from a jurisdiction that had substantially equivalent requirements for licensure?
Okay.
Or did, you should be able to see the statute now. So did they come from a jurisdiction that had substantially equivalent requirements for licensure? Or did they demonstrate that they had practiced as a psychologist at the doctoral level for 48 of the preceding 54 months immediately preceding the application, and then the absence of serious disciplinary nature, and then a doctoral degree in psychology from a regionally accredited university or college. And so some of the main focus has been talked about by the other advisory committees has been is that language that really talks to the having been registered, certified, or licensed psychologist at the doctoral level for 48 of the last 54 months immediately preceding application. Is that is that a good period of time to be one of the standards for reciprocity? For comparison, the bill that passed last year that provided a new pathway for reciprocity for military members, military spouses, individuals who are Kansas residents, and those that are intending to reside in Kansas, indicated that if you do not come from a jurisdiction that has substantially equivalent license requirements, they look at whether you have a similar scope of practice to the individuals providing services at this level, and then have you practiced in that jurisdiction for at least a year. And then there's some language involving disciplinary type things and a few other minor requirements, but essentially it for those who qualify under that bill, it provides a similar scope of practice and a 1-year practice requirement in that jurisdiction. So one of the main questions was, is that 48 months something that we should continue to keep in the statute, or is that something that perhaps could be adjusted?
So functionally, so there's a difference of 6 months in there. So I could have practiced for 3 years, then taken a little break and practiced for another year. And then that's okay. Or, well, I guess the first question is, first of all, is that length of time, does that seem necessary for reciprocity, or is it less than that? Or more than that?
In my mind, it's less than that. It seems like to had to have practiced for 4 years essentially to be able to be considered seems lengthy, especially in a mobile society where people tend to move quite a bit. It's just odd to say 48 out of 54 months. That just seems, I don't know what the rationale for that time frame would have been.
The 4 years is down from 5. Initially, the 48 of 54 was because if someone accidentally let their license lapse for a week, they couldn't come through reciprocity, even if they've been practicing for 20 years. Because it was without, you've been licensed this period. That's it.
Okay.
No exceptions.
So it was intended to help people out.
Mhm.
Right? So if someone had just let it slip. Okay.
Right.
So this was intended to help out people. And you say it's down from 60 months.
Yeah, the initial reciprocity law was 5 years, and then a few years back they lowered it to 4 years.
I guess
So
my
Doug-
question is, oh, go ahead.
No, go ahead, Tiffany.
No, I was kind of following up with Doug. What's the rationale behind the 48 months? Is it that it lines up with other states, or we need time to see if their license has been in good standing for, a period of time? I'm not really sure why it's so long. And maybe that's not important to know, but
I can tell you, when they went to 4 years, the rationale, but this wasn't for psychology, because psychology has a more your requirements, even though they differ, they're more uniform than a lot of the other professions. So the other professions it was 2 renewal cycles. That was their rationale.
David, do you know anything of comparable laws? Maybe this is asking Tiffany's question the same way, but comparable law in other states when it comes to this sort of stuff?
It's really challenging right now. States are passing a lot of changes in law in terms of reciprocity. So we attempted to look, and I talked to some of the associations to see if they had records of different reciprocity requirements. But the problem is some of the information they provided, they said, we can give you this, but we can't guarantee you that it's still current, because states are basically really focusing on workforce issues right now. So I can't really tell you with any certainty kind of how we compare to other states in terms of the length of time. Just so that I can say that compared to that bill that passed last year, 4 years is significantly longer than the new standard, which would be 1 year with a similar scope of practice. But not all individuals fall under that modification of the law, because it would be military members, military spouses, Kansas residents, and then individuals who intend to reside in Kansas. Now, I think one thing that may be different from us versus some of the other professions, that was sort of a large attempt to cover a lot of licensed professions. And some of those professions, you really have to have a hands-on approach. So you are going to be physically in that state. With telehealth, there's a fair number of our licensees that live in other states. And so there's a fair number of people who might apply for licensure that do not live in Kansas, but might provide a significant amount of services by telehealth. So that is just one of the differences. But right now, those individuals would not qualify for reciprocity in the same way, because they're not living here and they're not intending to live here.
We had a conversation about, and this maybe I'm muddling some things here, about states that this distinction would have been whether or not they have like a jurisprudence exam. Wasn't that part of this discussion as well, or the whole issue of reciprocity?
Well, I don't know. We don't look at that because we don't have one.
Yeah.
So we essentially look at if they did an APA accredited program, they took the EPPP and they did a year of postdoc. The year of postdoc is causing quite a bit of trouble now. because there are, I don't know how many, but lots of states that don't require a postdoc year now. Missouri being one of them. So that's really what I see. California is an equivalent because they have schools that are not regionally accredited. They just are designed to meet California licensure. And so they don't have any accreditation nationally or regionally.
Yeah, when I posed my question, I was actually thinking about Missouri, what it took to actually get licensed in Missouri. And it was, I didn't even think about number of years. It was really, I saw focused on passing their
Jurisprudence.
test. Yeah.
So one thing to think about too is that if you did want to make an adjustment to the statute on reciprocity, this would be something, as it's a statute, it would have to go into a bill before the legislature. And then it would have to be passed to become law. If you wanted to modify anything in the educational requirements for licensure under the regulations, that time frame is different because we can submit changes to regulations at any time. But if the statute was something you wanted to modify, we wanted to allow you the opportunity to discuss it before the legislative session started in case you wanted to make any recommendations on it.
So it sounds like we're not doing motions, but there's at least one idea that we could reduce the 48 to something smaller than 48, which would be in line with the bill that was passed last year, right? So that there's a little bit more parity across people who are in the military or intending, whatever all of those groups are that are included in that one bill, which so we could go all the way down to what that one does. It's one, if that's 1 year and similar scope of practice, right?
Yes.
That's what theirs is, yeah. But you could do substantially equivalent requirements or 1 year of license and practice. I mean, you don't have to change to similar scope of practice if you don't want to.
Leslie, I thought you've had to ask me about similar scope of practice a couple of times. Where does that fall in? If it's not here?
It's not our law, it's a state law. It's
Oh.
the 48-3406 is the 1 year and similar scope of
Okay,
practice.
that's why you've asked me about
Yes.
that one. Is someone coming in under that situation?
Yes.
Got it.
This statute in front of you is the one that's reciprocity specifically for licensed psychology. And
Yeah.
so it includes the traditional way to get in through reciprocity.
Okay.
The other one is more of, it was passed for all professions, all a number of other agencies and their levels of licensure. So we use that statute when we're looking at a lot of other individuals, but the main one here is the licensed psychology
Got it.
statute.
Okay. Does anyone want to make a recommendation to make a change? Or do we want to think about it a little bit longer? If we think about it longer, we may be missing our boat to change it in the next legislative, because we won't meet again probably before that bill is.
Correct.
Yeah, no, the session starts next month.
Yeah.
Yeah, I would make the recommendation to lower the time requirement from 48 months to 12, and having it be non-consecutive, as Leslie had mentioned.
For the last 12 months, licensed.
Or 12 out of
12 out of
24 or
16.
something.
Yeah, 12 out of 16. Or 12 out of 18.
Yeah.
I like that. I would agree with that.
I can go for that too.
And then leaving one just as it is rather than going to scope of practice.
The thing that concerns me about one with the substantially equivalent, Leslie mentioned that we're using, are they from an APA accredited program? And we've had discussions in here about the shift in training programs moving away from APA. And so my concern there is I would hate to limit somebody because their program has moved away from APA, but is yet still a good high quality program and known to be putting out good psychologists. So I'd hate to limit Kansas by continuing to do that. I don't know if this is the place to change that, but I recall that discussion with Rick in previous meetings, and it seems important to make a distinction there.
Well, I think that's an important point, Doug, and I agree with you. However, I think if we leave this the way it is, and then if we're able to address, so substantially equivalent means we expect these kinds of things, right? It doesn't necessarily mean APA accredited, right? We expect you to cover this, this, and this. And the point that you're recalling that I made was, what we currently have doesn't necessarily look like what APA currently does. To me, that's a larger problem that needs to be fixed over there, which is actually the next discussion point. As it so happens, if we leave this as substantially equivalent and then fix what the state of Kansas says are the educational requirements, I think it all comes back into alignment, right? Because ultimately we want someone coming in to have a similar experience to what we expect. Now, what we currently expect may be different, right? But I think the place to fix that problem, Doug, that you're bringing up for us again, maybe in the next item.
Makes sense. I agree.
Does that make sense to you? Because that way, once we fix that, I think it pulls everything back into alignment. So someone coming in from Arizona or Texas or Oklahoma or wherever, we kind of want them to generally have the kind of training that we expect to see for psychologists, right? Okay.
Yep, sounds good.
So it sounds like we have general consensus on changing that to at least 12 of the last, did I hear 18 months?
Yes, I believe that was the motion. So
Do we need a formal motion and a vote, or is that that would probably be helpful?
yeah, let's go ahead and do that.
Okay.
I will second the motion, Jessica.
Okay. So let's see. I think
Richard moved.
Richard.
Yes,
was that
so
your
yes,
motion?
I propose, so I move.
Okay, Richard moved to change that to 12 of the last 18, and Jess seconded.
Mhm.
Okay, all in favor?
Aye.
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 Any opposed? Okay, well, that's something else we did. Look at that. We did two things.
Awesome.
Yeah.
And Rick,
I
and
love when we get things done. Well,
Look
you
at
guys
that.
get
We've done
done,
things.
and I benefit from it.
Okay, good. Well, I want to make sure you benefit from it.
Rick, in the interest of time, since the regulation changes can be submitted anytime,
Yeah.
it may be helpful to go ahead and just move the next item, the one that talks about the educational requirements and regulation, to the next meeting.
Yep.
And just talk about the statute that has to do with good moral character.
Yep.
Okay.
It's good plan.
Okay. I'll go ahead and share my screen on that. This was something that had been pointed out to us. In terms of our license requirements, the other professions include, instead of having a requirement of, here's 74-5310, A2, one of the requirements for licensure is to be of good moral character. And in the regulations, good moral character is not defined. And in terms of looking at other states and looking at what is required, good moral character is really something that has been phased out in favor of meriting the public trust. And so I included some documents in your packet, just as an example, the social work requirements for licensure, that just kind of shows, it talks about meriting the public trust under here. 3, satisfy the board that the applicant is a person who merits the public trust. And in terms of that, there is a definition to meriting the public trust that is already in regulation for that profession that I believe is pretty consistent with the other professions. But meriting the public trust means that an applicant or licensee possesses the high standard of good moral character and fitness required to practice social work, as demonstrated by the following qualities: good judgment, integrity, honesty, fairness, credibility, reliability, respect for others, respect for the laws of the state and the nation, self-discipline, self-evaluation, initiative, and commitment to the social work profession, values, and ethics. And so why this is relevant is that if an individual does apply for a licensure, right now, if someone perhaps had done conduct which might be a violation of good moral character, the board could certainly look at evidence of that. But I think a better standard going forward for the profession would be to be consistent with other professions in other states and request a statutory change to modify good moral character to meriting the public trust. And then once that's put in statute, you could request a change to the regulations to add a definition of good moral character, meriting the public trust. So wanted to see if I wanted to explain that, and then also say that if you're in favor of that, that would be something you could make a recommendation to the board to request in statute for this next session. So, and Leslie, were you going to add a comment?
I was just going to say, and legal counsel suggested this. They felt it would be a good move. It clearly defines what's needed, so there's teeth behind the decisions.
Yeah, so I guess if you have any questions, we could answer those. If you agree that is a good positive change, then we would be looking for a motion to go ahead and request a statutory change to strike the requirement of good moral character and replace it with a requirement that the applicant merits the public trust. And that would be the only real change. And then we would come back to you if that statute had passed, and then talk about the next step after the bill became effective.
It makes sense to me. Anybody opposed to it?
No, and I can just tell you, just based on a number of good moral character is very, very hard to address when you're dealing with complaints and all of the other stuff. Whereas the list of merits of public trust is a whole lot easier to deal with when we're dealing with complaints and stuff. So
Yes, that is very true. That's very true.
You know now, huh?
I know. Oh, yes, yes.
Yeah. So is
I
someone
would
interested?
move that we strike moral character and replace it with merits public trust.
I second the motion.
Okay, we have a motion on the floor and a second. Is there any further discussion? Okay, all in favor of that motion, please indicate by raising your hand. Aye.
Ah,
Aye.
Any opposed? Okay, that motion carries, I believe. Okay, so we're down to discussion of 2023 advisory committee topics and discussion of meetings. So was there something in particular on discussion of topics? I mean, we've kind of punted on the educational thing, so that'll probably take a little bit of time next session. I guess we haven't punted. We just ran out of time to take care of them. So we didn't punt. The clock ran out on us. So
Okay.
we left it all on the court.
Definitely.
Yeah. Okay.
And I did include on the agenda, if the meeting dates do stay the second Tuesday of the month, then those would be the dates listed below in item 7. But I just kind of wanted to provide it on here in case you wanted to have any conversation about meeting dates in 2023. If there's no change, if you have agreement today, then I could go ahead and schedule these and send out calendar appointments to you all. So.
Not to be too much of a softie, but I wonder if some of our significant others might appreciate it if we didn't meet on the 14th exactly. So for
That
some
might be nice.
people's significant others might not want us spending time with each other as much as we would enjoy that. But just thinking of people's significant others who might be not present here to express such a thing. Maybe we could move February forward or backward a week and then take the rest of them kind of like they are.
I think that's a good idea.
You think that might be good
I
for
think that might please some people.
some people in the
Some
world?
people.
If you want to do that, I'm going to ask for one Jewish holiday.
Absolutely.
Okay.
So,
I haven't figured out which one yet, but I'm going to ask for it.
okay.
Make it one of the fun ones.
Yeah, exactly. Maybe like
Well,
Yom Kippur.
Yeah, Purim, I think, is the second Tuesday in March, if I'm not correct. And so, but you can find another one if you would like. Okay. All right. So we've kind of gotten through that. Is there-
And Rick, did you want to agree on one of those dates? I checked the calendar. We don't have any conflicts on either the first Tuesday, February 7th, or the second Tuesday, February 21st. Or I guess the third Tuesday. So,
Right. Oops. Well, at the moment, my calendar is wide open on the 7th and the 21st. So I don't have a preference. Anybody have a
That's in February, right?
February? Yep.
Um, I'm good on either one of those.
I'm fine with either.
Either one.
Looks like it's executive director's pick.
all right, let's go with February 7th. I'll schedule that. And then I'll go ahead and send it out.
Sounds great. With that, the chair would entertain a motion to adjourn if there was such a motion.
So moved.
Second.
Oh, don't be too hasty on that there, Rodney. It's like you don't want to spend time with us.
Oh, Mr. February 14th, God. Please.
Okay. Well, we have a second. And so all in favor of adjourning, please say aye.
Aye.
Aye. All right. You all have a great evening and we will see you all in February.
Yes. Happy holidays to you all.
Happy holidays.
Thank you again.
Thank
Happy holidays. Y'all take care.
Happy holidays. Thank you.